Canada is a beautiful country, and this year marks the 150th anniversary of the signing of the British North America Act, which officially made Canada its own country. It also marks the 35th anniversary of the introduction of the Canadian Charter of Rights and Freedoms, a document from which many Canadians gain a great source of pride. However, we must not sit idly by and assume that what we have is the best we can do. We can always be striving to do better to guarantee the rights and freedoms of Canadians. Some people think that the Charter does this well enough already, but as I hope to show in this video, I believe the Charter is actually a very fundamentally flawed document that, in several places, undermines its entire purpose and integrity. Much like the American Bill of Rights, the Charter ostensibly guarantees Canadians certain rights and freedoms that the government cannot infringe upon. However, there are three key problems with the Charter, and one key omission that I think undermine its core purpose. The first major flaw with the Charter is right at the beginning, Section 1 of the Charter. Section 1 reads, "The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." Now, what does this really mean? It's somewhat confusing, and I actually had the chance to ask a lawyer about this. Basically, it seems like an escape clause because it is an escape clause. Essentially, it allows the judiciary to decide, seemingly arbitrarily, that a certain law, despite violating the Charter, can be demonstrably justified as, I guess, beneficial to a free and democratic society. And therefore, the judiciary can choose to ignore the violation of the Constitution of that law if they think it will be beneficial to the general public. Now, how is this really applied? Now, I was told once that this has been used to uphold hate speech legislation in Canada. However, I can't find any evidence of that. It seems that the pivotal test of Section 1 of the Charter came with what is known now as the Oakes test, which centered around a gentleman by the name of Oakes who was accused of selling narcotics. The Oakes test basically tests a law that is seemingly unconstitutional as to whether it can be justified against Section 1 with two key requirements. So, the first key requirement of the Oakes test is that there must be pressing and substantial objective in the law that's being challenged. The second one is that the means must be proportional, which includes the means must be rationally connected to the objective, there must be a minimal impairment of rights, and there must be proportionality between the infringement and the objective. Now, so basically there has to be an objective, and the infringement upon your rights has to be minimal. Now, frankly, I'm of the opinion that any infringement upon one's rights is too much. However, the Oakes test is not necessarily an absolute, and if a judge were to so decide, they could essentially just completely ignore the Oakes test and declare a law that is unconstitutional as being beneficial to a free and democratic society, and therefore allow a law that is in violation of the Charter to stand. The second major flaw is in Section 15 of the Charter, specifically Section 15, subsection 2. Now, Section 15, subsection 1 reads, "Every individual is equal before and under the law, and has the right to equal protection and equal benefit of the law without discrimination and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability." And that's perfectly acceptable. That's something we expect of a free and democratic society, is that everyone will be treated equally. The problem becomes when you look at subsection 2. Subsection 2 reads, "Subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability." So what is this? Essentially, it's something that allows you to completely ignore subsection 1 as long as it's beneficial to an identifiable minority. And what that's known as usually is affirmative action. Frankly, I oppose affirmative action. I believe it to be more discriminatory than it is beneficial. And from what I've heard, it's actually not very beneficial to the individuals it's meant to be helping. Essentially, affirmative action can be detrimental not just to the business, but also to the individual the business hires. For the business to be running optimally, the business wants to, when hiring an individual, select the best candidate for a job. However, when there are certain quotas for diversity that a business must meet, the business will then sacrifice certain candidates who are better than others in order to hire candidates that will fulfill this diversity quota. This leads not just to the business not hiring the best individual for the job, but it also leads to the individual who is hired questioning whether they were truly the best choice or whether they were simply hired just to fulfill a quota. Canada is the only country, to my knowledge, to enshrine the right to affirmative action in its constitution, and that's not a good thing. It's discriminatory and harmful, and completely undermines the entire purpose of Section 15, subsection 1. The final major flaw is perhaps the most concerning one in the Charter. It is Section 33, the notwithstanding clause. So concerning, in fact, I've actually decided to list it by name. Now, the notwithstanding clause, Section 33, reads as follows. 1. Parliament or the legislature of a province may expressly declare an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15 of this Charter. Section 2. An act or a provision of an act in respect of which a declaration is made under this section is in effect and shall have such operation as it would have but for the provision of this Charter referred to in the declaration. Section 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such an earlier date as may be specified in the declaration. Subsection 4. Parliament or the legislature of a province may re-enact a declaration made under subsection 1. Subsection 5. Subsection 3 applies in respect of a reenactment made under subsection 4. Yes, this section literally allows the government to enact a law that they know is unconstitutional and say it will be operating regardless of the Constitution. Now, it does have some limitations. First is that the law will expire after 5 years, and the second is that it's only allowed to operate on sections 2 or sections 7 through 15. The problem is those are all the really important parts. Section 2 covers your fundamental freedoms, things such as freedom of expression and freedom of religion. And sections 7 to 14 are your legal rights, the rights that apply when you get arrested, or the rights that apply that lead up to you getting arrested. And section 15 I already covered is equality rights. But again, what does this mean? The particular example I like to use to demonstrate why this is so bad is a little bit extreme. And it relies on a specific assumption beforehand, one that I hope to elaborate on in a later video. The assumption is that the death penalty is not actually against the Charter of Rights and Freedoms in Canada. And as I said, I hope to address that in a later video. However, running with that assumption, the notwithstanding clause essentially means that Parliament could enact a law that says something to the effect of, notwithstanding Section 2 of the Charter of Rights and Freedoms, anyone who says the word purple on a Tuesday is subject to a penalty up to and including death. As I said, it's a bit extreme. However, when I look at this, it's theoretically possible. This is perhaps the most concerning thing because of all of the rights that it allows the government to blatantly ignore. Now, how has this actually been used? Because it has been used in the past to basically have the government declare that they are going to ignore the Constitution. The most infamous example of the use of Section 33 is from the province of Quebec, to use it to support Quebec's language laws that declare French to be a superior language to English, despite the fact that in other places in the Charter explicitly states that English and French are to be treated equally in terms of their legal power. The only other major place it's being used is in Saskatchewan, to force a striking union back to work. I believe a law should be judged not by the good it can do when it's applied correctly, but by the bad it can do when it is abused. And Section 33 has very high potential for abuse. Through Section 33, the government could enact laws, either all at once or separately, that infringe upon your freedom of speech, that infringe upon your freedom of religion, that allow the government to detain you indefinitely, that allow the government to search you arbitrarily without reason, and that could even allow the government to legalize torture. That is why I believe Section 33 is quite frankly the most concerning part of the Charter. It is an escape clause and an override to give the government superior power over the Charter. And they knew that, and that's the whole purpose of Section 33 existing, was the government wanted to give themselves the ability to override the Charter if they thought they needed to. And frankly, I don't think the government should be able to override a citizen's rights. Now, I mentioned also at the beginning that there was one key omission from the Charter of Rights and Freedoms that also detriments the document, and that key omission is property rights. Now, there is a Bill of Rights 1960 that guarantees property rights to some degree. However, it's very shaky at best, the guarantee. Now, Pierre Trudeau, when he was patriating the Constitution, wanted to include property rights in it, but omitted them at the request of the provinces. Why is this? Well, it's because then the province wouldn't be able to seize your land for public works projects, such as the construction of highways. And they also wouldn't be able to go and sell your land separate from the rights to the minerals and trees on that property. So that mining and forestry corporations can go onto your land and tear down the trees and dig up the land, potentially even without your permission. Now, without the guarantee of property rights, it really means, unfortunately, that anything you own, you don't really own. And the government could potentially seize it at any time without offering you any compensation. And I can tell you that's actually already happened in Canada. There's not many people, I think, who will be horribly sympathetic towards firearms owners, unfortunately. However, they are the people who have had this happen to them the most. There have been guns that have been owned by firearms owners that have been confiscated, whether because the government declared they could not be passed down to the owner's children, or whether because the RCMP decided that one day the gun was legal, but the next day the gun was not. And the RCMP then seizes these firearms from the estates of these people who passed away, who can't pass them down, or from the hands of these people who purchased them ostensibly legally, because the RCMP allowed these guns into the country. And of course, in seizing these guns, the RCMP offers absolutely no compensation for this. And the problem with this, doing this even with firearms owners, is that it sets a precedent that this kind of behavior is legal and acceptable to do, which means that if the government so chose to, they could seize basically any of your property without having to offer you any kind of compensation for doing it. Now, what can you really do to stop this? Unfortunately, the reality of the situation is not much. Since the Charter of Rights and Freedoms is a section of the Constitution, it would require a constitutional amendment to change. And a constitutional amendment requires support of 2/3 of the provinces, making up at least 50% of the population of the country. More or less, this means without Ontario's support, no constitutional amendment can go through. And it's very unlikely also without the support of Quebec. And Quebec is actually the main reason why any constitutional reforms are not going to be going through anytime soon. Quebec actually never originally signed the Constitution when it was patriated in 1982. And this is because the separatist premier of Quebec put forward a list of demands that the other provinces and that the Prime Minister did not want to meet, that basically would have put Quebec in a special situation above all the other provinces, which is frankly not fair. Now, the Premier of Quebec has been talking recently, saying that he wants Quebec to sign on the Constitution. However, he is still sticking to those same original demands that were unreasonable back in 1982, as if they, for some reason, have become more reasonable as time has gone on now. However, if you want to remain optimistic about something, then what you can do is write your Member of Parliament and your Member of Provincial Parliament, which in some provinces is called the Member of the Legislative Assembly. Because this requires the support of not just Parliament, but also the provinces, you have to make sure you send the same message to both. That the Charter of Rights and Freedoms has some flaws to it that should be addressed in order to better guarantee the rights and freedoms of all Canadians. If you're still watching this video at this point, thank you very much. This is the first video in a series that I hope to do about or relating to the Charter of Rights and Freedoms in Canada. And I thought since the other videos will all harken back to this document, I should give you some background on my opinions on the Charter here. If you disagree with my opinion or if you have anything to add, please feel free to leave it down in the comments below. Again, thank you very much for watching. I am Chris the Canuck.